Yes, Mr. Pine.
My lord, my point, my lord, we have to clear, my lord, the LVO report, which the ACE exhibit annexer ACE. This is for reverse the, my lord, initial doubt of the electoral registration officer. This is not the basis for reference. The basis of reference is the doubt arise before in the mind of the, my lord, electoral registration officer when he, my lord, examined the voter list of 1997.
See, Mr.
in extensive
Pine, and
revision.
very recently, in few days, a few weeks back, you have given us that
Yes,
election.
yes, yes.
Why don't you file an affidavit? Here is a case, there is, as of now, notice haven't been issued. Right? Only the thing is, because this is very important, if not for today, for tomorrow. See,
This is settled, my lord. This is the numbers
where,
of cases.
because we have not seen any such judgment where they considering the ERO's note. That is also on the basis of the guidelines issued by the election commission, how the EROs proceeded.
My
How the
lord,
EROs proceeded, because Mr. Ali on last occasion have given some photostat copies because I read it.
Yeah.
The thing is that is not in the form of any affidavit. Because in that particular period, to assess who is, whose name is to be considered as a doubtful or what, on what basis, that the guidelines was issued.
some judgments I can refer, my lord. Sayamuddin, one judgment is Sayamuddin that was in the single bench that was upheld by the division bench.
Division bench.
Yes, that point
Justice
was
Sharma's judgment, I believe.
Sayamuddin was, my lord. No, no.
Can you give us the citation?
My
That
lord,
WBC
another
number?
my lord, in that time,
See, otherwise, if you read the Muslim Mandal case,
yes,
there is direction to the inquiry.
yes,
But that is a matter of inquiry of
police
inquiry.
inquiry. That is not
nothing to do
that
with
has
the
not
voters.
touched the, my lord, the
The voters.
reference coming from the electoral registration officer.
Right.
That has not touched anything on that.
Exactly.
Mhm. Reference. First of all, your lordship may kindly see one judgment of this, the SRA Chaudhury's case, my lord.
That I know.
Yes.
Because
There this, my lord, the entire the process was silenced. The, my lord,
that is with regard to that matter where the division bench set
Yes.
aside that order. And it was also challenged in the apex court, I think so.
yes,
It was
apex-
dismissed.
Yes, it was dismissed, my lord. The
But
this
that relates to a few documents, not with the entire matter.
no, there, my lord, this matter, this issue has been discussed.
No, is
The
it?
present issue.
Let us see. Give us the number.
Just a minute. Yes. It is, my lord, SRA Chaudhury's case, my lord. Civil rule, this is, my lord, 2002, 1 GLT 1, my lord.
One. Yes.
Para 6, my lord, that issue, para 6 of the judgment. May I read them?
Please.
It appears from the Election Commission of India, herein referred as the Commission, has issued instruction from time to time to the Chief Electoral Officer, Assam, for intensive revision of the electoral rules in Assam, with reference to the 1197 as the qualifying date. This instruction of the commissions are contained in the communication dated 1796, 4297, and 11/7/1997, copies of which have been annexed to the reply affidavit filed on behalf of the commission. The instruction of the commission which provided the cases of persons whose citizenship is in doubt are to be referred to appropriate tribunal for determination of the citizenships are contained in paragraph 3.8, 3.9, 3.10 of the guidelines annexed to the communication dated 17/7/1997 of the Commission of the Chief Electoral Officer Assam, the said paragraphs of 3.8, 3.9, 3.10 of the guidelines are quoted. Here the procedures are quoted. Now we can see 3.8, what it says. The electoral registration officer shall, on receipt of the verification report from the local verification officer, this is after receiving the, before that the ERO send a matter to the verification officer for verification. The electoral registration officer shall, on receipt of the verification from the local verification officers, consider the same. They will consider the ERO where he is satisfied on such report and such other materials information as may be available to him.
You are reading which para?
Para 6, 3.8, 6 in the 6, 3.8 has been quoted,
Yes,
Para
please.
6, yes. May I read once again? 3.8. The electoral registration officer shall, on receipt of the verification reports from the local verification officer, which is the annexure, this is the local verification officer's report. Consider the same. He will consider the same. Where he is satisfied, he has to be satisfied on such report and such other materials, information as may be available to him about the eligibility of a person, he shall allow his name to continue on the roll and include it in the final roll. That was in the 1997 draft rule. When in the draft rule, the person's name was suddenly appearing, my lord, the ERO sent the matters to the LVO for verification. When he received back the verification officer's report, and if he is satisfied, yes, on these materials, his name can be continued in the voter list, his name will be continued in the final voter list of 1997. That is the point, man. In the final rule, where, however, he is not satisfied and has reasonable doubt about the citizenship of any person, he shall refer all such doubtful cases to the competent authority under the Illegal Migrants Determination of Foreigners Tribunal Act 1983 or the Foreigners Tribunal Act 1946, as the case may be. This is the case, Mal, where from this local verification officer's report, if the ERO is not satisfied, he has no alternative option but the matter to send to the Foreigners Tribunal for a reference. That's why I'm saying, my lord, the verification officer report is for reversing the, my lord, preliminary, my lord, the doubt created in the mind of the, my lord, ERO on the basis of this in the extensive revision of 1997 voter list. But here, in all cases, the petitioners, they argue that as the verification officer's report doesn't contain anything, he cannot be referred to the Foreigners Tribunal. This is reverse, my lord. The verification officer report is for the reversal purpose of the preliminary opinion, preliminary doubt of the AR, not the basis for reference. This is clear from this, my lord. One GLP one. Phase one. 2002 one GLP phase one. পুরোনো বহুত পুরোনো বিখ্যাত মূল আর্গুমেন্ট আছে
Please take your seat, Mr. Pai. Six. Yes, Mr. Pai.
My lord, the process initiated like that. Thereafter, my lord, made it the next paragraph also. As the case may be, for the convenience of the electoral registration officer, the commission has devised a proforma annexure B for making such reference, which shall adopted by the electoral registration officer. While making such reference, the electoral registration officer shall also furnish to the competent authority, this is the my lord, foreigners tribunal, all documentary evidence collected during the process of verification. All documentary evidence, my lord. It has to be including the local verification report. This report has to be sent along with the minute at Annex B, pertaining to the person concerned, and also inform the person concerned of his case having been referred by him to the competent authority. So this is the initial stage of reference. Thereafter, my lord, 3.9, after the case of the person has been referred by the electoral registration officer to the competent authority as aforesaid, he shall wait for the decision of the relevant tribunal in relation to the person and act according to such decision. So once reference is made by the electoral registration officer, he has to wait for the decision from the foreigners tribunal. Then 3.10, my lord, where the relevant tribunal decides that any such person is not citizen of India, the electoral registration officer shall proceed under Rule 21A of the Registration of Electoral Rules 1960 to have the name of such person deleted from the electoral roll before it is finally published. The electoral registration officer shall issue notice as required under the provision to the said Rule 21A of the Registration of Electoral Rules 1960 to the individual concerned in the prescribed format. This is the handbook is referred. Now, in further appearance, so in this was silenced, my lord. Para 7, your lords, you will find. This instruction was silenced. Silence, para 7, it is said, silencing the instruction of the order of commission put it above. This thereafter, my lord, D were marked on the basis of that against those persons who have been referred, because it was a large amount numbers, my lord. So all the cases could not be trial in the same time. So D were marked against those persons, and they were gradually sent to the foreigners tribunal for reference.
Now, you have seen Mr. Bikeda's name.
Yes, ma'am.
Do you know who was he? You know him as a senior lawyer,
Yes, ma'am.
right?
Yes.
He was studying in Cotton College. He was made the secretary
Yes.
for settlement and rehabilitation of partition displaced Bengali Hindus. He was for a very long period as a secretary of placement of the partition displaced Bengali Hindus that came after the partition. So if you go to relate it back to the history, you'll know, because otherwise we all know him as a senior lawyer.
Yes.
His role.
Then this was silenced. There are lots of discussion on this.
The other person,
Yes.
right? And do you know if their background, both of their backgrounds relates to two different political parties? Yes.
And lastly, my lord, these instructions were silenced. Those were upheld by the honorable court.
Where is the finding?
Finding the last. My lord, will find para 15, my lord. Considering, however, the gradual manner in which reference are being decided and the state
Mr.
was
Payak, at times it is, it is very important that nowadays you have Rajya Sabha TV and the other TV, right?
Yes.
Those parliamentary debates is very important. In fact, this is because I used to be in archive and read all these things. That's why I'm telling you at one point of time. There was a minister at that point of time. The road, my residence in the same road in his name, Rohini Kumar Chaudhary.
Yes, I know.
Right. So he used to, during our school days, hardly I was in school. I remembered him in that way. His house.
He was in the Constituent Assembly.
Yes, member of the Constituent. His role with regard to the partition displays Hindus, because there are many things there. If you read the assembly debates, yes, you'll know many things. What happened at that point of time?
Yes.
It is there in the archives, but it is even the archives of the assembly. Yes. But it should be in electronic form, because I don't know to which extent the books are there. It has to be the government tried, because earlier was the chief secretary. He was looking after the archives, both of the assembly as well as the archive of Assam. Borua, what was his name? Jishnu Borua. During his time, archive reached a particular height, and he has done lots of contributions there. And then, but not all the old records. Yes. From a particular period, because old records, as you know, the pages whichever is available. And we have a bad habits, our scholars, they used to tear off the pages from the books. If you go to
Whichever is
Kamrup
necessary.
Anuhandhan Miti, there are books from 18 centuries. It's a very, very sad. They have thrown away all the papers. The books are there by the name only, but you will not find any page there. The relevant pages are missing, but they are scholars. And unless those books are not reprinted anymore, you will not get. Yes,
So, my lord, from
it is the para
What-
15.
14 and 15, there are 14 onwards, my lord. In fact,
Mr. Dasgupta, there is a famous Bengali writer, lady. She has written in sequels, 3 books. I forgot her name.
Nohonnate,
What was her name?
Maitreyi Devi.
Maitreyi Devi. Now, much before Maitreyi Devi, much before Maitreyi Devi, there was a lady writer in Assamese. Her name is Torulata Dr. Borua.
Yes.
Earlier, there was a bookstall published from Dibrugarh and Shillong, Sopola bookstall.
yes,
No longer there in Shillong, no longer there in
Chapala bookstore is not, no.
It's
not
in Shillong.
available.
I have
It's there.
seen,
It has been, those books are not available.
Those books are never,
Now,
bookstore
I
is
have
there.
seen the bookstall still there.
And
in
one
some
It is
bookstore
there
was
in
a
the corner
Mokkada
of that
Pustaka.
ASTC bus stand in
Yes, near
Shillong.
STC
That
bus
down
stand.
below there is.
One
those
bookstore was at the Mokkada Pustakalaya.
That's right. Thing is
Professor
this,
Jatin Bhattacharya.
March before the Nohonnate and everything, you should read the books of Torulata Dr. Borua. I don't think so. If somebody somewhere in some library it is available, very, very thick book. And there are certain books of Torulata Dr. Borua, then you will realize how at that point of time during the British rule or old days, the girl children are not allowed to go to school, how they used to read. And the society of that point of time. You will see something in the books of Maitreyi Devi, because her reading is also the woman oriented.
No, this book has been translated in English also.
Many books, because I have read in the original Bengali, but thing is this much before Maitreyi Devi. That's what I'm saying.
And counterpart book was also written in the French language.
That's right. But much
that
before
way.
Maitreyi, that is what I am saying. Torulata Datta Borua wrote sequels in Assamese. I forgot. One is Govir Gopan, I remember still, and the other one I forgot prior to Govir Gopan. The first book, it was very old book. And those books are missing now. You will never get it anywhere.
No.
You should find whenever you go, if you have in your
District
place.
library,
Yes.
I tried, because I tried to read those books once again. Those novels are not available. I remember one book on the name Govir, but prior to Govir Gopan, there was another book,
Torulata,
Dr. Borua.
I shall try to collect it.
Should. Very old book. Very old. Because you know Kanchan Borua, right?
Yeah.
Famous books are there prior to that. That is why I'm saying much prior to that. Yes, proceed.
Para 13, my lord, last part. After, my lord, does some, my lord, last part, para 13, last part. My lord. Does the submission of Mr. Das and Mr. Bhuya, learned counsel of the petitioners, that once the name of the person is entered in the final electoral roll, he cannot be disallowed from exercising his right to vote under Article 326 of the Constitution and Section 62 of the RP Act 1951 is misconceived. In our considered opinion, if such a person whose name has been included in the final electoral roll suffers from the disqualification of not being citizen of India mentioned in Section 16 of the RP Act 1950, he cannot be allowed to vote in view of the specific provision of Article 326 of the Constitution, Section 16 of the RP Act 1950, and Section 2E and Section 62, Clause 2 of the RP Act 1951. Thus, the instructions, guidelines, and orders of the Commissioner constitute consistent with the constitutional scheme and provisions of the RP Act 1950 and the RP Act 1951. So, guidelines, sir, are upheld. So once the guidelines, if we follow the guidelines, but we have to follow the guidelines. And following that guidelines only, the tribunals are functioning. Man. Tribunal, the reference are made by ERO.
Paragraph 14.
Para 14. Further, the provision of RP Act 1950 and RP Act 1951 are general provisions made for the entire country, and the Parliament, while enacting the said provision, has not provided for the peculiar situation relating to the influx and presence of large number of foreigners in Assam. For such situation of presence of large number of persons who are not the citizens of India and who are not entitled to register themselves in the electoral rolls under Article 326 of the Constitution and Section 16 of the RP Act 1950, and have no right to vote under Section 2E and Section 62 Clause 2 of the RP Act 1951, the Commission could issue instructions, guidelines, and orders in exercise of plenary power under Article 324 of the Constitution. Such instructions, guidelines, and orders, however, should not be arbitrary or affected by malafide or particularly partiality, as has been held by the Apex Court in the case of Mahinder Singh Gill. In the case of Lalban Hussain Supra, the Supreme Court issued some direction to be followed in case of persons, citizens who was in doubt. Perhaps paragraph 3, 4, 5, and 6 of the said directions of the Supreme Court of Lalban Hussain's case are quoted herein below. Number 3, madam. If any person whose citizenship is suspected is shown to have been included in the immediately preceding electoral roll, the electoral registration officer or any other officer inquiring the matter shall bear in mind that the entire gamut for inclusion of the name in the electoral roll must have been undertaken, and hence adequate probative value be attached to the factum before issuance of notice and in subsequence of proceedings. Number 4, the officer holding the inquiry shall bear in mind that the inquiry being a quasi-judicial nature, he must entertain all such evidence, documentary or otherwise, the affected person concerned may like to tender in evidence and disclose all such materials on which the proposed to place reliance, so that the person concerned has had a reasonable opportunity of rebuting such evidence. The person concerned, it must always be remembered, must have a reasonable opportunity of being heard. Needless to state that the officer inquiring into the matter must apply his mind independently to the material placed before him and without being influenced by extraneous consideration or instructions. 6, before taking a final decision in the matter, the officer concerned will bear in mind the provisions of the Constitution and the Citizenship Act, extracting herein before, and all related provisions bearing on the questions of citizenship, and then pass an appropriate speaking order since appeal is provided. Thus, as per the aforesaid direction of the Supreme Court in Lalban Hussain's case, in case of persons whose citizenship is suspected, the electoral registration officer or any other officer inquiring into the matter before taking any final decision in the matter has to bear in mind the provisions of the Constitution and the Citizenship Act extracted in the judgment, and all related provisions bearing on the questions of citizenship, and is also required to give all reasonable opportunity to the person likely to be affected by the order that the process to pass. Since the provisions of IMDT Act 1983 or the Foreigners Act 1946 have bearing on the question of citizenship of the person, the electoral registration officer cannot ignore the said provision which inter alia provided for decision by the tribunal constituted under the said act, said 2 acts relating to the citizenship status of a person. Moreover, paragraph 3.10 of the guideline in the instruction of the commission dated so-and-so provided that where the relevant tribunal decides that any person is not citizen of India, the electoral registration officer shall issue a notice as required under the provision of Rule 21A of the Rule 1960 to individual concerned in the prescribed format and proceed for deletion of his name from the electoral rule in accordance with Rule 21A. The proviso to Rule 21A of the Rule 1960 stipulates that before taking any action for deletion of name a person from electoral rule under Rule 21A, the electoral registration officer shall make in every endeavor to give him a reasonable opportunity to show cause why the action proposed should not be taken in relation to him. Thus, the impugn guidelines of the Commission also provides for reasonable opportunity to a person whose name is proposed to be deleted from the electoral roll and is in consonance with the rule of law and direction of the Supreme Court in Lal Banu Hussein's case and cannot be held to be arbitrary or violative of malafide or partiality. This is in Malat again. Considering, however, the gradual manner in which reference are being decided by the state of Assam by the tribunal, such persons whose cases are referred to the tribunal constituted under the IMDT Act 1983 and the Foreigners Act 1946 may suffer great prejudice if the tribunal take years to decide the reference made to them. Section 13 of the IMDT Act 1983 provides for expeditious inquiry by the tribunal and casts an obligation to the tribunal to make all the endeavor to conclude the inquiry within a period of 6 months from the date of service on the person conferred concern of a copy reference for application. We are of the view.
Is prior to 2025. That is the reason.
Yes,
why
that is prior to
before
2005.
the Sarvanda
Yes.
Sullivan one judgment of the apex.
Well, this is referred
that
either
means-
to, yes,
But the remaining portion of the enumeration and the doubt of the ERO has been prescribed in that particular office memorandum and the guideline.
Yes.
It has been upheld.
upheld. That has been upheld. So on the basis, my lord, on that basis only ERO, as
So
I have,
the guidelines that were challenged issued from time to time in these 3 periods.
yes,
But the division bench have challenged, of course, there is a judgment thereafter. It has been
Yes.
challenged before the
Yes.
apex court.
Apex court also, that
Do
was
you have
upheld.
that decision
Apex
of the
court, my
apex
lord.
court decision.
Apex
It was
court
dismissed.
decision, there
If not
was,
today,
my lord.
Mr. Ali, Mr. Puli, you can give it to us.
Yes,
You can
Okay.
give it to us.
no,
There somewhere,
Okay.
it was placed. The dismissed in the SLP. This
yes,
decision
SLP was
challenged.
dismissed, my lord. I'll provide that, my lord. Okay.
Why it was a PIL? How come it has become PIL? Because the, Mr. Chaudhary filed it.
Yes, my lord. It was filed by Mr. H. And some organizations were also there under this. So that's why I'm saying that the present, if your lordship go through the records, there are two annexures, Annexure A and Annexure B in the original record. Always there is two annexure, my lord. One is by the verification, local verification officer, one is by the ERO. ERO make the reference. The local verification officer, he submits the verification report to the ERO. As I have said, my lord, if then ERO satisfies on the basis of this document that yes, his name can be continued in the voter list, then no reference. No reference is necessary. He will directly allow the person to be continue in the voter list, in the original voter list. Then there is no question. If the ERO is not satisfied with this report, then he has no alternative, my lord, but to send the matter to the foreigners tribunal. That is the point. So from this, my lord, Annexure A, it is seen that nobody can satisfy, my lord.
Where is Mr. Ali? That's important for it. Whenever he's free, just ask him to come on, come to. Now, Mr. Dasgupta, since this particular link between the proceedee and her projected brother was not before the tribunal, how do you say that this order of the tribunal is bad?
No, only one thing, Lord, I have not, I may require some time, but what I have understood from the reading paragraph, Lord, that the material in relevant documents is this rule, this finding. In addition to that, some other documents. So,
See,
so,
basically,
so, just a minute. While the presiding officer of the tribunal shall proceed, he must apply his mind on this document. So if you go to this document, there is nothing. On the contrary, this document supports me. So there is no whispering about this thing. Well, I will place it after some time, about today or tomorrow. Another thing that I would like to place before your lordship, that is, your lordship has rightly pointed out about the jurisdiction of writ of certiorari. There are some grounds that where there is an error apparent on the face of the record, errors of law, etc., etc. But one thing that is very much clear, my lord, that when there is a perverse judgment, in that situation also, my lord, writ of certiorari may be applicable, my lord. Now, if your lordship come to page 23. No, so far this judgment is concerned, your lordship may kindly give me 1 day time, my lord. I will just point it out.
Payang, provide the judgment of the apex court, Justice Pardiwala's judgment.
Yes.
To Mr. Dasgupta.
Now, page 23. Decisions and reason therein. That is hard decision.
Yes.
In the voter list of 1966 of village Mondia under LSC number 52, Bagbor, Exhibit A, the name of Rabendra Saha is enlisted at serial number 271. And in the voter list of 1970, the village Mandia, LSC, Bagbor, the name of Rabendra Saha is enlisted at voter list of 251. OP has claimed that Rabendra Saha is her brother. OP has examined this Rabendra Saha as DW2. In his cross-examination, DW2 has stated that OP is his sister. OP has claimed that he is my brother, and DWT has stated that he is my sister. That he does not know the residence of his father. That he, along with his brothers and sister, brought up in the residence of his maternal uncle of village Mandia. That he does not know from where and when his father came, that he does not know when and where his sister was born. From the evidence of DW2, it cannot be established that OP's father and mother were inhabitants of Assam on or before 1996. Now, how the two can be used? Even if you go to what led her to bring this?
Go ahead, go ahead.
There is no such reason whatsoever assigned, Lord. From the evidence of DW2, it cannot be established that OP's father and OP's mother were inhabitants of Assam. Is it not perverse? Is there anything in the evidence on record? Simply he said, I do not know my father's original residence. From the deposition of DW2, it cannot be established that OP has born in the year of 1952. He specifically says, I do not know the. And Mandya, Exhibit D is the certificate issued by the Gao Panchayat Secretary of 68 Mandya Gao Panchayat, where it is stated that Josna Rani Saha, daughter of late Dinesh Chandra Saha, and late Sarabala Saha, mother, is an inhabitant of the village Mandya, Mauja Sachen Mandya, police station Bagbor, district Borpeta, Assam, know him, issuing person. From the contents of this certificate, OP citizenship or parent citizenship cannot be established. Moreover, the truthfulness of the contents Exhibit B is not proved by examining the issuing person. From the certificate issued, Exhibit D is the certificate issued by the village headman of village Mandya and Mundya, father Pathar, Mandya Pathar, where it is stated that the name of Sri Ramendra Kumar Saha, son of late Dinesh Chandra Saha, village Mandia, Mouja, Mundia, Bagbor district, Borpeta, is enlisted in the voter list of 1966. Her father's name was also from the documents of OP, cannot claim that the Ramendra Saha is her brother and his name enlisted in the voter list of 1960. From where or how she could came to this conclusion? Is it not purpose funding?
Where from?
Yeah, from the document of OP,
Hmm.
opposite party, page 24, paragraph
Yes.
2. From
Yes.
the document, her conclusion, inference, from the document of OP cannot claim that Ramendra Saha is her brother.
Hmm.
Ramendra Saha is telling that she is my sister. She is telling that Ramendra Saha is my brother.
Go ahead.
And his name is enlisted in the voter list of 1966. And being sister of such person, opposite party is also a citizen of India, has not proved the contents of this document, Exhibit E.
What is Exhibit E?
Exhibit E is the certificate issued by village headman. The person concerned was not exorbitant probably.
And Exhibit E is the Gambura certificate.
Yes.
Now, please come to page number 21.
21.
Hmm.
Yes, please.
That is the Gambura certificate, which was not proved.
Yes, that is right.
But even then, you kindly read.
21, no? Actually, it's not very
It's in vernacular.
particular. My here is not very much.
Annexure D. Annexure D.
Annexure D, my photocopy here is not very eligible.
Let me read it.
Yes.
Praman
I-
Patra?
I can read. I
Ah.
can-
No, let me read it better.
Yes.
Praman Patra.
The
Praman Patra-
original record is there, blood.
প্রমাণ পত্র দিয়া হয় যে রমেন্দ্র কুমার সাহা 1708 just now. রমেন্দ্র কুমার সাহা পিতা দীনেশ চন্দ্র সাহা থাং মন্দিয়া মৌজা মন্দিয়া থানা বাঘবৰ জিলা বৰপেটা অসম উপৰোক্ত মানুহজনৰ 1964 চনৰ ভোটাৰ তালিকাত 52 নম্বৰ বাঘবৰ বিধানসভা
Yes.
সমষ্টিৰ খণ্ড নম্বৰ 51 ঘৰ নম্বৰ 61 ক্ৰমিক নম্বৰ 271ত মই জনামতে নাম আছে
So that is
উক্ত
why the
মানুহজনৰ ভনীয়েক শ্ৰীমতী জ্যোৎস্না ৰাণী সাহা হয় উপৰোক্ত তথ্যখিনি সত্য now this particular exhibit it was issued a certificate by the concerned Gambura on 17th of August 1993 just a document it has not been proved
but yes.
before
That is
the
correct.
tribunal
That is
so
correct.
where is the illegality on the part of the tribunal
No, I am not telling you. Let her be content with this finding, Lord, that you have not proved this document through the person concerned who wrote it. That's all right. But
so that is why the tribunal came to
but
finding.
one thing, when the DW1 and DW2 statement is correct there, and one thing is, after all, we are doing substantial justice. One thing that he has said that her father's name is also enlisted in the.
Reason, please go to the judgment of Justice Padiola. It's very, very specific. You will know what is there inside because in that particular judgment, His Lordship have
2023.
clarified certain things.
No, what is the citation?
2023. 2023.
2023 SCC online.
SCC online.
It was a
SCC
judgment of
online.
last August.
SCC. SC 996. SC 996. SC
All right.
online.
You'll get it from paragraph 50 or 54, Mr.
50 onwards, ma'am.
50 onwards.
50.
All right.
In between, there is a particular paragraph which is very, very important. When? Thursday?
Any day. Thursday or
अपनी
all right, let me try.
Hard in part. And before that, you heard Mr. Ilyas Gopal and its senior counsel, assisted by Miss.
Thursday,
And counsel for the
what are you
petitioner.
for it? Oh, no, Thursday, I have one engagement.
Wednesday?
I have to address in a seminar.
Wednesday?
Next Tuesday,
Next Tuesday?
because I have to address one. Or that 11, sorry.
Okay, next Tuesday,
Thursday is 30th, no?
but mind that
30.
next Tuesday may be an important day for you, not for us.
No, I don't know that.
Okay, so
I
in
have
that
to,
case, we'll have
I
it.
have to perform my duty.
Okay, for many it is something a different day.
I don't have any interest on this. Election will. Nowadays, I don't.
No longer involved.
No, I'm involved, but I'm not interested so much. Because what will be the result probably.
Okay, anyway. We are not on that, right? And Mr. Zay Pang, pending council home department. Mr. Ali, pending council election commissioner, and Mr. P. Sharma. For correspondence. Yeah, already. Right. हाँ एक है मिस एक है आया part important please 04 06 2020
Much obliged. No, so in this case, your lordship calls for the lawyer record. So the record has not come yet.
My lord, we have communicated, my lord, but probably the communication from the High Court has not been received.
not
But
necessary we ask you
Yes, my lord, the records are, my lord, they are transmitting it by tomorrow morning. So can it be fixed day after tomorrow? Any day?
on the prayer of Mr. Zay Pang, standing council home department list on Friday.
Record like isn't it?
Huh?
Record like
Validate.
Please, your lordship.
Just a minute. Part mistake. बाकी records of FTT within bracket. Case number 01/2006 was called for 01/2006 of the Fairness Tribunal past Morigaon, wherein the impugned opinion was issued. Order was passed on 21/03/2011, was called for by order dated 01/05/2024. Office note dated 24/5/2024 reflects that the same is yet to be received. Same has not yet been positive. List after 3 weeks. Immediate to be fixed.
My lord, in this case, lordship, as per direction of the IGP border lordship, one PS case has been registered against those person lordship. Abdul Nur Saman, earlier proceeded lordship, and detailed instruction is not yet received lordship. This was Murajar PS case number 13 of 2024. registered on 25/1/2024 under section 120B, 419, 468, 471 IPC.
On instruction from the Superintendent of Police Board, Ojai, Lonka, Mr. Z. Sharma, Standing Counsel from Department submitted that a police case being which police station?
Muradjar,
Muradjar Police Station, case number
MURAJHAR, Muradjar. TS case number 13 of 2024,
13/2024 under sections
120B, /419, /468, /471 IPC.
has been registered against
Read with section 14A of the
section
Foreigners Act.
14A, 14A, then
14A of the Foreigners Act, Lordship. Foreigner.
against whom?
Against Lordship Abdul Noor Samad. Abdul Noor Samad.
Hmm.
ABDURNWRSAMAD.
Who is he?
Earlier proceeded, Lordship. He was earlier declared foreigner. After remanding the case, again declared as not foreigner, Lordship. Then local people lodge a complaint against this person, Lordship.
Hmm.
And inquiry was made accordingly and found some by using some fake document, Lordship.
But you have not initiated any case accepting this police case.
Lord,
He has
detail,
been declared an Indian.
yes, Lordship.
The state did not file any case.
Lordship, detailed instruction is not yet received, Lordship.
Go on.
Read with section 14A of the Foreigners Act, Lordship.
Hmm.
It with
Against Muhammad Abdul Noor Samad, son of Haji Abdul Samad of village Borpukri,
son of Abdul Khalik.
Abdul
Khalik, Lordship. KHALIK.
for submitting fake documents before the tribunal. And obtain order in his favor pertaining to his nationality. Tribunal to foreign staff. Second Hojai. That's Sankatatnagar. In FT/L/ case number 1494/2018. Decided on 16/10/2020. Next week. Issue notice returnable by 6 weeks. as Mr. B. Chakraborty, Planet CGC, comma, Mr. AIL Standing Council Election Commission of India, Mr. G. Sharma, Standing Council Home Department. Technically, B. Chakraborty, Planet CGC for the response number AIL for two. Technically, B. Chakraborty আজকে দ্বিতীয় পূর্ণ কথা এই কারণে মিস এই কারণে Mr. Z. Sharma, Standing Council Home Department for the response number 2, 4. Abandoned, no comment this. Petitioners shall serve requisite extra copies to certain persons. On or before 30. 2024. After name is acknowledged from them in that paper. Petitioner shall take steps by registered society. Response number 5. On or before 30. 05/2024, providing correct. Yeah, the impugn opinion dated 16/10/2023. Passed in FT/L/ case number 1494/2018. Being passed by the Learned Foreigners Tribunal, Second Hodai at Sankatev Nagar, Hodai. According to us, is not a necessary party for proper adjudication of this case. According to the name of the respondent number 6 from the cost type. We did registry shall do the needful according. Respondent numbers 1, 2, and 3. One to 4 shall file their respective affidavits. In time. This is clear. Mr. Sharma, Mr. Ali, and Mr. Sharma. There are judgments of the apex court panel or high court. There is a good judgment of Honorable Justice P.K. Sharma of that. That's in service matter. But with regard to the other matters, you will see the judgments of the Honorable Apex Court. You will see whenever a petitioner, any candidate in that case or a proceeding before the tribunal or before the court submits any effect to establish his right to a post or whatever, then what will be the right of that person? Whether the court should consider his case, whether his rights, including rights of nationality or citizenship, which people are claiming to be a fundamental right, has to be considered. How a person
Yes.
who relies on certain fake documents to establish his right
Hmm.
in those matters, how the Honorable Apex Court have dealt with
Hmm.
it. Very good, sir.
Cross vitiate everything, Lordship.
Very good, sir. Try to find out. And what will happen if that particular person is fundamental? Forget about his arrest, keeping in bail. What will happen?
Hmm.
It will subsist or it will not.
Yes.
Fundamental right. Very good. Just like in the delay,
Yes.
if there is unexplained delay for a very long period,
Yes.
whether a particular person will have such fundamental rights,
Yes.
even if it is up to delay. There has been dealt with by recent judgment.
Hmm.
Of course, old judgments after 1967 is very clear.
Hmm.
Thereafter 74. But now the recent judgment is also there where those judgments have been considered. Similarly, with the persons appearing before the court or a tribunal, quasi-judicial authority, with respect to. In service laws, you will get many.
Hmm.
See those are. You will be required to place it in your affidavit.
Yes.
Go through it. No representation on behalf of the petitioner.
Nothing.
Nothing. The sir is not there, why should he be here? Come and pocket a sum. The response. Please stop. No representation on behalf of the petitioner and for. Mr. MS. Egan, Planet is the petitioner for. Mr. G. Master Nichols, from the party petitioner. And for. Mr. P. Sharma, turning additional scenario some petitioner for three. And Mr. A. I. Standing council. For petitioner for five. By our earlier order dated 20/04/2024, we call for the records of FT case number 8371/G/16 from the Learned Foreigners Tribunal number 1, Palpara. Wherein the impugn opinion dated 15/03/2023 was passed, opining the petitioner to be a foreigner of illegal migrant to the report as a kind. Office note dated 08/05/2024. Delete. The register received the relevant records outside applications. List of the two on a deputy expiry.
Lordship, in this case, I need further 2 weeks time, Lordship, to submit the inquiry report regarding fact certificate of school headmaster, Lordship.
On the prayer of Mr. G. Sharma, pending council home court, place this matter again on 12th of June,
Lordship.
enabling him to place the relevant.
May I please, Your Lordship, my lord? My lord, on the other day, my lord, I was requested by the my lord party concerned, my lord, with the assurance that my lord, I'll be submitting, filing the my lord, wakalat now, my lord, after getting NOC, my lord. However, my lord, they have not contacted with me, my lord. Therefore, my lord, I mean, difficulty to proceed in the case, my lord. And probably, my lord, he has been engaged in it.
Yes, Lordship, in this case, I have been engaged, Lordship, with the no objection certificate from the earlier council.
Did you file your Wakalat number?
Yes, Lordship, yesterday I filed my appeal.
My name may can be deleted, my lord.
Mr. J. Hamad, Learned Counsel, appearing for the petition. Submitted. That. On last occasion, I on 2005, before he appeared in the instruction of the petitioner. But subsequently, the petitioner engaged another counsel. And as such, he may be relieved from this case. And name will be deleted from the court list. As he did not file a color number on behalf of it. Mr. P. Chaudhary, Learned Counsel, has entered appearance on behalf of the petition. And on inquiry submitted that yesterday, on 27/05/2024, he has duly submitted the Wakalat number in the matter. By filing receipt number 3483 of the 2024. Dated 27/04. 27/05/2024. To that extent, petitioner has also placed the receipt regarding filing of Wakalat number on behalf of the presentation. In view of the discussion related in Mr. J. Hamad from the podcast. And shall incorporate the name of Mr. P. Chaudhary. For the- In it, I have in which
Lordship, in this case, Lordship, 3 weeks time may be allowed, Lordship.
next week. Registry already received the relevant records from the Foreigners Tribunal number 3 Morigaon. And it was called for by order dated 09/01/2019. Petitioner is already on interim protection. Since 18/09/2019. As by the impugned order. The impugned order dated 15/09/2018. Passed by Learned Furnace Tribunal number 3 Morigaon. In case number FT within bracket C. Bracket close 01/2016. has been declared to be a foreigner under the Foreigners Act 1946. Before that, you write. From the records of the case, it is seen that the Superior Police Board of Morigaon, by its communication dated by its reference dated 05/08/2002, while I am within bracket D, bracket close D, case number 346/2001, dated 25/05/2001. Referred the matter to the Foreigners Tribunal. Sorry, before the illegal migrant within bracket determination of tribunal. Determination tribunal. Under the IMDT Act 1983. During its force. And not against the petitioner numbers 224. In view of the above, the order dated 15/09/2018 passed by the learned Foreigners Tribunal, number 3rd, Morigaon, Assam, in case number FPC 01/2016. Against the petitioner numbers 224. Or hereby status has been passed. In view of this, the judgment of the court in instance of this court passed earlier. Where is the judgment? Justice Bhuyan's judgment. Mr. Sharma, where is the judgment? Proceeding was only regard to the petition number 1, the other proceeding. Without any entry.
Lordship, 2019 1 GLT 353 to Dhir Roy.
2017.
19 1 GLT 353.
Just
2019 1 GLT. Para 9.
as there was no proper inquiry against him. However, needless to say, the respondent authority, after making proper inquiry, the respondent was the competent authority. After making proper inquiry, may refer the name of the petition numbers to respondent petition number 2. the concerned tribunal.
Suddenly disappeared. I was deeply requested by them 3 times. The decision there and there, like, without submitting filing and collecting.
This process itself proceed only with regard to the petition number. Since the petition number 1 has been declared to be a foreigner under 6 has noted. In 1946, were illegally entered into territory of India in the Assam on or after 25/0/1970. He shall appear before the Instrument of Police Border Morigaon on or before 19th of June and shall obtain bail. The remaining portion is the group form or pronoun or allow. Issue rule. Place this matter for hearing only to be fixed by the registry. Registry shall retain the records received from the furnace tribunal. That's all.
Please, your lordship, like you brought another thing, lordship, petition on number 4 was expired, lordship, in the meantime, lordship. That's it.
We have dropped that case now.
Drop what is it?
Give it to us, give it to us. Will not say it. It has been dropped.
Hello.
May I please, your lordship?
RMS Zimora, counsel appearing for the petitioner. And Mr. MSK Gayan and HCC. For the response of Mr. G Sharma, standing counsel, Home Department, for the response number 1. and 3. Mr. P Sharma, Senior Government Advocate Assam, additional senior advocate for the response number 2. Who will represent ERO? You will represent ERO.
ERO AIL.
Mr. AIL is pending council election commission in India for the response number 4 and MS A Gayan, London CGC for the response number 5. Where was the office note? That 30/04/2020. Registry has already received the relevant records from the Furnace Tribunal, 2nd Nagaon. It was called for by order that 19/12/2022. Notice in this case was issued on 19/20. The petitioner is also interim protection and interim bail since 19/12/2020. Issue rule. Place this matter for hearing on a date to be picked by the registry. The records of the ARP case number 76/2016 received from the Furnace Tribunal, 2nd Nagaon be retained until further. Twenty-five, complete.
No, then to Amar.
25.
Then to Amar. Huh? Admission. Eight to Amar.
State of Assam.
Yes.
Lordship, if it is not inconvenient to Lordship, can we at 2 o'clock? I just want to peruse that NCR next.
My lord, may I please your lordship, my lord, what happened, my lord, in this case, my lord, Mr. M. Hawk is the leading counsel, my lord, and we were, my lord, there, my lord, but we thought that, my lord, he is appearing, my lord, but we have not able to contact with him, file also not with us, my lord. M. Hawk is the leading counsel, my lord. He is not appearing, that is why we have come, because, my lord, and we have not able to contact with him, my lord. With client also, my lord.
Minister of the council for the parties. List on third.
My lord,
Monday,
my lord, my lord, my lord. God bless, my
no
lord.
further time.
God bless, my lord.
Please your lordship, my lord.
Yes.
My lord, as per order dated 29/5/2023. Report was confirmed.
We have received the status report. We will try to get it. We go over and get it. No, no. Itu boleh, itu boleh. Itu jangan. Teman korek. Itu jangan tahu. Iya, sudah. Saya sudah. Gimana? Baik, yes. Investigation going on here. Jeres पर मारा था वो मिल जाते हैं तो पैसे यार खाने के सीधी लाइन पर ऐसे नहीं हाँ पिंक यार खाने को तो रिकवर तो करने के लिए कितना था लॉट ऑफ रिकवर का करने के लिए और स्टेटस देखो ना इस तरह से जो कर रहा है या तो अपने रिलेटेड स्ट्रक्चरल रिपोर्ट हाँ ऐसा से को भी याद नहीं सकते today we are receiving माझे पैसे 29 तारीख में कितना रुपये 29 से
Yes.
Thank you, sir.
My lord, the victim was not yet recovered, my lord.
Thank you for the investigation here, Aman. Okay, so I'm sorry. Okay, so मैं रात को खुली है तो सब मैं दिल को नल पे चले बॉडी को लेकर आया हूँ मुझे तो सब पढ़ाई से वो पर घटना तो इसे पता है आपको बिल्डिंग में तो
घटना तो पता है।
हम फिर बाद में करने को
Yes, মই মনত পৰিছে আৰু তেনেকুৱা আহিছে এইটো গ'লে আমাৰ বাকী এতিয়া তাত আছে পঠাইছে তাত নাই ডিটেইলছ আছে পুলিচ টিম অলসো এইটো কথাই তুমি তেলফালৰ পৰা কোৱা তুমি আৰু আমাৰতো আমি কৰিছো পুলিচ পঠাইছো আমি কি কৰিম এতিয়া হয় নহয় আমিতো পুলিচো পঠাইছো সেইটোৰ ওপৰতো কিবা আহিছে আমাৰো কৰিছে পুলিচ টিম গৈছে চেন্নাই তাৰে কিমান কৰিব সেইটো পুলিচ টিম তাতে আছে
নহয় তাৰ আগতে What is the report here with the Kolgosia police station? Do you have anything? With it? Matter has been transferred to Tamil Nadu. That we have.
yes that is
What was the enquiry?
inquiry report my lord inquiry report কি আছে বহুত আছে
You ask me.
one team my lord they are posted to Chennai my lord one police team they are posted to Chennai my lord but till now we have not received any investigation in our affidavit my lord page 36 there are 11 যেটা আছে রিভার্স স্টেটমেন্ট 2013 ডিসেম্বর ওইটা করে দিন
Affidavit matter page 36. Affidavit filed by SP matter. Affidavit filed Superintendent of Police page 36, para 11 matter. Paragraph 13, reputation demonstrated that action was taken as per the law, but arguing the victim who could not be traced fully despite of sincere efforts. From the investigation conducted so far by the investigating officer, it is learned that the victim about Abdul Rauf taken in the Saidul Islam, son of Usman Ghani, village so and so, Iman, and about 9 p.m. There was phone call was made by Iman. Subscriber named Azamuddin Mansi, who stated that he met the Abdul Rauf at Vyasar Wadi or Iman. He was wearing a slipper under his Genji and half pant, and he was found. He requested Azharuddin to give some money and his mobile to speak with his family. Accordingly, the IO had verified this and found that he had spoken to one Sahidul Islam of his village, Banguri. Next day, 11/1/2021, said Abdul Rauf called his mobile and stated that he is all right and soon he would return home. Said Sahidul Islam informed the matter to the wife of Abdul Rauf and his mother. After analyzing the CDR's police team under the investigating officer was deputed to Chennai in sufficient efforts to make the investigation officer with assistance the Chennai police details investigation have been stated so and so. Acknowledgement report on it. Investigation is going on. Investigation দিয়ে রিপোর্ট আসবে টাইপ করা আছে ছেড়ে বলে কেন হবো লিখি স্যার ফোন করবো এটা পাবো লাগবে না রিপোর্ট ইনভেস্টিগেশন রিপোর্ট যদি পড়া ইনভেস্টিগেশন রিপোর্ট বিচারিছেন তোমার পড়া ইনকোয়ারি রিপোর্ট
Why you have transferred the matter to the Tamil Nadu?
that he, that earlier, but that person, mother, he named
Abdul.
Abdul Ghaffar was beyond that.
Why,
My
what
lord,
is the reason?
my lord,
You have investigated at Kolgasia, right?
For investigation, my lord. We have sent
Now you
the,
have already transferred the matter to Tamil Nadu. Why?
my lord, the victim was taking from Kolgasia, under Kolgasia police station to Chennai, my lord, and missing from there, my lord.
they are from Chennai, my lord.
My lord, kindly see the affidavit filed by the SP, page 35, my lord. This report has not received, my lord.
You will also see the affidavit filed by the SP.
Page
SP
35, my
purpose.
lord, first para, my lord.
Page 34, lordship, era 5, my lord. हम तो बात ऐसे नहीं हमें बात ऐसे नहीं
Police station of enforcement of this, three report,
है काम करू से नहीं
काम करते लोगों ले गई सी ले गए और बना लोगों को यार इतना है ये बात नहीं
तो कोई दिया है कोई दिया तो कोई दिया तुम काम कर रहे हो ये तो एफिडेविट और ऐसे तो बताएंगे तो नेक्स्ट डेट देके आ गए ना बोलते को तो नहीं खबर है खुद ले क्या है लगे ना तो मतलब तुम डील को जैसा मैं बताइए जैसे
Sharma, who has transferred the investigation? Who is the authority to transfer investigation from one state to another state? Whether the OC can transfer it, or the Superintendent of Police Borbeta could transfer it. Under what jurisdiction?
that is the अरे भवन को कभी you know affidavit
Case has not been transferred, my lord. I have visited the place of Chennai, my lord.
lordship page 32 in affidavit mention here your lordship page 32 in our affidavit filed by the SP my lord may I read lordship that one I was examined Anjuara Khatun who stated that she has visited Chennai earlier for medical treatment along with the other state, Saharali, but was unable to proceed and commence medical treatment. She also said that she has no knowledge about.
Mr. Sharma, we are not asking you that. You have placed a communication,
Yes, Lord.
right? Who has transferred this case from Kolgasia to Tamil Nadu?
Superintendent of Police. Maybe.
Is it the authority under the CRPC? Who can transfer it?
Home the power. Home Department Department.
Earlier occasion, my lord, I was also called by the honorable court and
That is not the issue. We have seen that.
Transfer to Corona. Case has not transferred, my lord. For investigation only, police team was visited there.
helping from Chennai.
Oh, right. Helping from Chennai police, my lord. Because incident happened at Chennai, my lord, not here. Case register. Kolkata, no? At Kolkata. Case was not transferred.
Is there any provision in the CRPC to transfer a case or such investigation by the Superintendent of Police to Superintendent of Police of another state of a district?
That is no.
Where is that provision in the?
There is no such provision.
Then
No, my lord, the case was not transferred.
we understood even for
Not
the
transferred.
investigation.
Even my lord, case was registered here. And police team visited there. Because that,
No, police visited, they came, did not find him.
no, that
There is a case of missing person.
is
So how will happen?
not transferred.
Have you received any information? Has it been any case registered in this particular police station?
No,
Then what kind of information was it? It was given in last September 2023. We are end of May 2024.
we are not received.
Verma. During the deliberation of the matter, pertaining to whereabouts of one Abdul Rauf, ABDUR, ROUF. Who is missing since January 2021. From Chennai, Tamil Nadu.
6 January, my lord. 6/1/2021.
Mr. P. Sharma, Learned Additional Senior Advocate Assam. Placed a communication dated 29/04/2024 of the SP Borpeta. With regard to the status of Kolgosia Police Station case number 183/2021. Registered under section 365/34 IPC. Involved in this case. apprising the court that since the occurrence is under Koyambedu, Koyambedu police station of Koambedu, Koambedu district, Chennai, Tamil Nadu. For the interest of investigation, the case was transferred to the concerned police station, i.e. the Coimbatore police station, in Tamil Nadu. And that the original case diary of said Kolkata PS case number 183/2021 and the connected papers were sent to the Superintendent Police, Coimbatore district, Tamil Nadu, by a special messenger from Kolkata police station. Full stop. By this communication dated 29/04/2024, ASP Borpeta also placed before the court that the records of said Kolkata PS case number 183/2021 along with the relevant documents were received by Sub-Inspector of Police from administration on behalf of the Deputy Commissioner of Police Coimbatore district, Chennai, on 05/09 2023 itself. To that extent, SP Borpeta has also placed a copy of the receipt, such receipt by the SI of Police Administration of Coimbatore Police Station. On the next date fixed, the response number 5, Director General Police Assam, to its counterparts, the state of Tamil Nadu, shall place the up-to-date status regarding the investigation of the whereabouts of said Abdul Rauf relating to Kolkata Police Station case number 183/2021 which is now pending before the Coimbatore Police Station, District Coimbatore, Chennai. List on twenty-seventh of July, sorry, June. A copy of this order be furnished to Mr. P. Sharma, Additional Senior Government Advocate Assam, for his necessary use. Any, further. Communication dated 29/04/2024 of the Superintendent of Police Borpeta, placed before the court today, along with the receipt of the relevant records and documents of Kalgosia PS case number 13/2021 by the SI of Police Administration, Office of the Deputy Commissioner of Police, Coimbatore, Chennai, dated 02/09/2023. Be kept as a part of the record.
Under extra copy, we have no extra copy, my lord.
Will they make a photocopy? And take it? Just tell us who are the hearing. Look, our name for the response number.
BJP की वजह से
Who else is ready for hearing? Have to come back at 2.
Item 12 may not be taken today.
Why?
Not
Reading,
ready,
that's
sir.
why.
BJP
Come back at 2.
My lords, in item number 11, the affidavit is being filed today.
नहीं नहीं ये 11 का क्वेश्चन है बस ना बस ना just now.
And my lord, regarding the Vinikata PS is number 28 of 2013 and 30 of 2013, we received instruction. Both the cases are under investigation by independent highway.
Affidavit kon bisa niki tabe affidavit ko itu bisa niki
Right. Separately.
ini bilang affidavit sama naik
Still investigation since last 11 years.
Sir, that is the instruction by law.
We are asking you what is the updated status. Investigation is there, we know.
Yes, ma'am.
That is not the instruction, ma'am. You must tell us. This cannot be, we are not interfering with the investigation. Right, the thing is that we should know for 11 years if it is pending for investigation. Pursuant to the order at the previous order at the 30/04, 30/04/2024. Mr. MSP Sharma, Learned,
You shall.
sorry, Mr. MSU Sharma, Learned, Government Advocate Assam. Apprised the court, who filed the affidavit? The
SP Chirag, my lord, respond number 7.
The response number 7. Superintendent of Police Cherang filed its affidavit today, by serving in copies of the same to Mr. A. Chaudhary, counsel for the petitioner, and Mr. R.K. D. Chaudhary, learned deputy SGI, respondent number 1. Counsel for the respondent members 1 to 3. Not 1 to 3, 1 to 4. List on. Eighteenth. In the 20th.
My lord, one more submission, if I may say that. In the affidavit in opposition filed by the respondent number 1, 2, and 3, at paragraph number 17, they have stated about 4 reports. My lord, in actuality, B and C, the government of Assam has ordered one-man inquiry by an additional chief secretary level officer, and the one-man committee report pursuant to the HRC order. Both the reports are one and the same inquiry.
Shown us last occasion.
Yes, my
We
lord.
have seen that.
So,
Both the reports are together one.
together one, so in total, there are 3 reports, my lord.
What they said there? The SP Chirang, respondent number 7 shall also apprise the court about the updated status regarding the inquiry pertaining to regarding the investigation of the Ranikata PS case number 28/2013, as well as Ranikata PS case number 30/2001. Registry shall incorporate the affidavit of the respondent number 7 filed today in the case record.
Obliged, my lord.
Ms. Sharma, this is not an instruction.
Yes, my lord. My lord, I'll obtain further instruction on it.
That's, we all know investigation. That is the reason we wanted
Yes,
to know
my
what
lord.
is the
Yes,
status
my
of
lord.
investigation.
Definitely.
May I please?
It will be consent for the petition. When,
After 4,
why so special?
after 4.
Sixth.
Yes.
On the prayer of Mr. Raymond, it will be counsel for the.
May I please, your lordship?
Yes,
Lordship, a short date may be fixed, your lordship. I'm not prepared to.
these are hearing. And it's a hearing on hearing date only. Since 2017, the matter is pending and the proceedings on protection.
Yes, your lordship.
You have to play. You have to play. You have to work. Means auto forward. Okay. Rama. আর তিন মাত্র মাটিতে মাটিতে তাহলে কি মানে কোন প্রকোপটা হচ্ছে সাইড প্রকোপটি পিছন করে ঠিক করে ও ঠিক কোনো কর্পোরেট এসির ফেন টু বুঝছি ঠিক Yes, what is there to prove? What is the illegality of the order? Will you be able to show it?
Lordship. Her father name is Kapashu Sheikh.
Hmm.
His name has been recorded in the voter list of 1966.
Hmm.
Along with his mother, Fulbhanu Nessa is the mother. 1966 voter list. And also in 1970, your lordship, father and mother, both names is there.
Just a minute.
That's it. Night.
Yes, please submit.
Lordship, I pray for some time, your lordship. I'm not prepared.
Tomorrow. At 2.
Actually, I've accepted nothing in this case.
I thought she was taking that. When he is not there, but
Well,
tomorrow at-
It's a covered case, Lordship. I mean, all these are translated copies.
we'll look into that.
Lordship.
Oblige.
Tomorrow at 2. Hardin part. Mr. Sikka, you are here? Oh, my lord.
Already, LCR was for thought.
Take it. My lord. Pardon me, sir. Here, Secretary Council Academy. And a colleague of Standing Council Department. Sara Patel, let's take a and I think super also for this very Council Department for the and Mr. Sorry, Colonel Council Petata. It's good. Pursuant to our earlier order at the 2004 that is of received the relevant records of FT case number 1871 public C of 16 awareness tribunal number wherein the private had even opinion 15 open the petition for another person. Next. Petitioner shall take step. Six by the step of subject to appearance of the petitioner before the Supreme Court on or before 19th of June 2028, she shall not be taken into consideration, shall not be reported. Territory of India. Option B, not be dated 2020. Honest number.
Deep level.
Mr. Mahmood, you are ready?
Actually, I'm not so ready.
No, if you want to argue, we'll hear you. That's all. Up to you.
Next item, I am ready, my lord, but
Which item?
next, that is item 17.
17.
17, I am ready.
On the prayer of Mr. Amin Mahmood, consider asylum.
Item 17, Lordship, I don't have the file, Lordship. Item 17, possible, Lordship.
Rest of the items will not take it. We'll take up this separate. Because brother has a single bench. Mr. Mahmood, just take your seat. You can call them.
Hold on. I think 17th, no? Oh. 17th. Sharma.
Blessing.
Go to- go to-
There was an actually. Perfect, yes. Perfect, yes, very good. Absolutely. Not fully.
Yes, Mr. Mahmood. Let us proceed.
Thank you, Lordship. My lord, the petitioner Raheton Nessa, she was born at village Kasarigao under Morigao PS. That is page 4 of the writ petition. Her father's name is Sekandar Ali and mother's name is Amena Khatun. And after attaining the age of majority, she was married to Hassan Ali, son of Karamat Ali of village Thengaguri Pathar village in the district of Morigao. But after 4 years, her husband died. Just after 4 years of her marriage, her husband died. So she came back to her parents' house, that is village Kasarigao, and started to live with his parents. At that time, they were dead. So with his elder brother, namely Kashevali. So she was born at village Kasarigao under Morigao PSN district, this is Nagaon district. And secondarily is her father, Amena Khatun mother. She was married to Hassan Ali. Hassan Ali died after 4 years of marriage. She came back and started living with her elder brother, Kashim Ali. Now, From that angle, Lordship may kindly see page 17. This is page 17. This is the voter list of 1966. In the name of Sekandar Ali and Amina Khatun, her parents.
Yes.
Village Kasarigao, PS Morigao. The same place where she took birth. Then Lordship may kindly come to page 19.
Yes.
This is also village Kasarigao. It is voter list of 1970. Page 19. Then Lordship would kindly come to page 21. This is the NRC details. Name Sekandar Ali. Morigao. So, this is the NRC details. I am not on there so much because NRC is not the proof of citizenship. Now, Lordship may kindly come to page 23. This is also the NRC details. Sekandar Ali, village Morigao. At the time it was LC Bokani. Bokani as Sisurigas constituency. And Thana Morigao. So this is shown. Then Lordship would kindly see page 25. In between, this is an NRC, so these are not so much important. Page 25. This is the voter list of 1997, where Kasem Ali, her brother's name, and Rahatan Nisa are together. So Kasem Ali is the DW2 man. So Kasem Ali is the son of Sekandar Ali, and Rahatun Nisa is the daughter of Sekandar Ali. So both of these persons' name are together. Now Lordship would kindly see page 27. This is Kasem Ali, Sekandar Ali, Ajiran Nasa, his wife. And in 2010, page 29, in this voter list,
This is 1997 voter list, you say it? Your name and your brother's name figured together?
together. 1997, page 25.
But this is not a certified copy.
It is the electric generated,
Even then, it will not, it is not elected.
but it is exhibited, my lord. It is exhibit 97. It is exhibit 5. It is exhibit 5. It was exhibited.
This is not the exhibit. The exhibited document is before us. It contains the name of only two persons. One Muhammad Kasem Ali and Miss Ajiran Nisa.
Aziran Nasa, his wife, and Rahatan Nasa, his sister.
It is not there in the voter list. The exhibit 5 here before us in the record.
Exhibit 5. This
It's a
case,
1997 voter list, no doubt. It's a 1997 voter list pertaining to Dolgaon LSC from number 5, Boruajhar.
but in the judgment I will show you. Let me go first. In judgment, it is reflected. Judgment is my opinion.
Exhibit 5 in name of Rahatan Nisa is not there. This is, the record is before us,
Kashim Ali and Rahatan Nasa are together.
not there. Only Qasim Ali and Ajiran Nisa is there. You can verify.
The Lordship McAllister, page 26,
Before page 26.
serial number 50. Kashim Ali, Aziran Nasa, Rahatan Nasa together.
But this is not a certified copy.
Though it is not certified copy,
Then how will you, public document, you have to place a certified copy? Or have you adduced evidence of any election office?
no, that was not done. That was only 2 persons are there.
So
So
you can verify.
if your lordship is on that,
No.
even then,
You should be satisfied. This is the exhibit 5.
I am satisfied. I am coming to
The fact-
2597, page 25. In addition to this, I have some other document. And now kindly see page 27. These are the (1997). Only 2 persons' name is here. But Lordship would see 97 voter list, serial number, if we go to serial number, 97 voter list, serial number 168. But it is not that voter list. Here is only 2 persons I have seen. Let me see further documents, if any. Now, 2010, S29 voter list. Here, Kashim Ali and Rahatan Nasa's name appeared together in the voter list. This is 2010. 2010, it is the abstract of voter list 2010. Here is both Kashim Ali and Rahatan Nasa is there, page 29, together.
That is also not a certified copy.
It's not certified copy, of course, it is not certified copy. Then Lordship would see page 31, this is compared with original, the election voters ID. Here, Kashim Ali, my brother, and Kashim Ali's father is secondary. It is written. Kashim Ali, voter ID card, and his father's name has been written as secondarily.
This is the exhibit 6.
This is, yes, this is duly exhibited. Exhibit 6. So it is proved with original. Now, Lordship would kindly see page 32. This is the land purchasing deed. Kashim Ali, son of late Sekandar Ali. So this is the registered deed.
Which date?
Kashim Ali's father is Sekandar Ali, it is proved everywhere. Now, Kashim Ali's name appears together in the voter list. Of course, that is the certified copy. That is not certified copy. Here, Gowra's certificate is there, but Gowra was not examined. Page 36. Here, that certified that Mosammed Rahatun Nisa, daughter of late Sekandar Ali, village Kasarigao, post office Gaglamari, Mouza Pokoria, T.S. Mayong, district Morigao, Assam. I know that the above addressed woman is resident of Gaglamari, Gao Panchat, under Mayang Revenue Circle. I know her very well. The said woman was married to one Muhammad Hassan Ali, son of late Karamat Ali of village Hati Lurua Pathar, post office Thengakuri, P.S. Lahorigarh, Mouza Lahorigarh, Rajaghat Revenue Circle, district of Morigao. So this is the certificate of the government Gowra. Then Lordship would kindly come to page 38. This is also another certificate of Gowra. It is from husband village, I think, because this is certified that Rahatun Nasa, daughter, it will be wife of Hassan Ali, village number 5, Burwazar, Mouza Pushim Dolgao. So that is her matrimonial address. So this is, and this is, I think, this is exhibited. This is, my lord, exhibit 9. Exhibit 9. Now, written statement, let me read the written statement on page 40. 40. Para 4 onwards. From 2, Lordship would say that after attaining majority, she was married to one Hassan Ali, son of late Karamat Ali of Thenga Kudi Pathar of Morigao district. So now 4 may be seen. Due to erosion of father's house by the river, the said family started to live permanently at 5 number Burwazar, P.S. Dolgao. So shifting from Morigao to Dorong district due to erosion in the district of Dorong, Assam, and thereafter enlisted their names in the voter list. At the first instance, D has been inserted against her name, and after receiving the notice from this honorable FT, she has submitted it. So D was inserted because normally when the girl is married to another village, she becomes a new face and the police officers doubt. So her name was recorded there, but with the letter D. And then she appeared and stating everything. Now kindly see page 41. That father's name of second party is late Sekandar Ali. Mother's name is late Amena Khatun. Grandfather's name is Chaudhary Munshi. So these are her own brother's name is Kashem. So this is important. In the WS, she is bringing Kashem. And own sister's name is Aisha Khatun. Her son's name is Abdul Rahim. So Kashem is here. Then Lordship would say that mother of second party was residing at Kasarigao village under Morigao, PS in the district of Nagaon since before 1966. The parents second party have casted vote in the year 66. So 66 is there always. And legacy that I am not giving so much importance. But kindly see now 11 members. Serial number 11, that there is There is the legacy data of the year 19 in the name of second party's fathers. So this legacy data was used by both Kasem Ali and Rahetun Nessa. So in that view, it is important. Then Lordship is para 12. Second party's mother and brother have casted vote in the 1993 under 68 number Dolgaon LSC, village Burapar, Dolgaon, Assam, district Dorang, by serial number so-and-so, house number so-and-so. But her mother's name has been wrongly recorded as Amiran instead of Amina Khatun. And her age has been recorded as 47 years instead of 78 years. So it has, she has clarified this position. These differences in names and ages, she has clarified in the first instance at the time of coming to the court, to the tribunal. And 2010, in that second party's brother casted vote in the 2010 under 68 number Dolgaon LSC, in the district of Dorang. In that name, 2010, her name is also there with her father, but certificate copy was not produced. Certificate copy was not produced, but actually that should not be taken so seriously because there are so many persons named. Government advocate did not raise any objection at that time. They did not raise any objection. This is not certificate copy. There is no such thing, madam. Now, para 18 may be seen that the Election Commission of India has issued voter ID card in favor of petitioner in the year 2013. So this voter ID, her name is there with father, second, her name is there. And white number so-and-so, voter ID has been issued to her. Then Gaubura certificate, again Gaubura certificate, then Gaubura certificate, then 23, there are many other relevant documents which should be submitted at the time of evidence. Both the second party and her brother has filled up NRC form in the 2015 using the legacy data of 66 of her father, white legacy data number so-and-so. So same legacy data was used by Kasem and Rahetun. So it means that secondarily is their common father. And secondary's name appears in the voter list of 66 and 70. So this is very important, madam. Same data. Same legacy data used by both the brother and sister. That police has never seen or asked to show document by the second party. These are common thing. So, my lord, from the very beginning,
Mr. Mahmood, here the proceeding
Yes.
try to establish the link of her
Secondary.
father, Secondary Ali through her brother Qasim.
Yes.
Because Qasim Ali has been shown to be the son of Secondary.
yes,
That is why it says that since he is the daughter of Secondary Ali, Qasim Ali is also daughter of Secondary Ali. The name of Secondary Ali along with his wife, that is the mother of the property, figured in the voter list of 1966 and 1970 from the constitution opening of district Morigaon. So earlier no. So that's how they linked to the group. Right now, no such voter list produced before the tribunal to show that her name and name of Qasim Ali together at any point of time. Those documents which you have annexed here, not the certified copy.
That's right.
Exhibit 40, right?
exhibited, but not certificate.
It's not exhibited. Exhibit, that is the reason you are telling you. The exhibits are different. You verify. Exhibits are different.
Exhibits means
This 1997 voter list exhibited before the tribunal doesn't constitute the name of the petition. Because the certified copy of 1997 voter list was placed before the tribunal. In that voter list, name of Kashem Ali and his wife figured, not the name of the petition.
in the certified copy. But in the next copy, that
That
is,
is which you have annexed here.
yes.
Posted copy.
So it's on record, my lord.
Not been proved.
I cannot go beyond record.
That's
So,
Now, what is the link between you and your brother or you and Secondary Ali?
my question, my submission is here.
You want to prove that you are the daughter of Secondary Ali, whose name figured in the 1960, 1970 voter list, 1966 and voter list. Now, there has to be some link. The person, the certificate given by the government Gaambura, he did not deduce any evidence.
No, that was not done.
And secondly, there is also defect in it because it has the national emblem and others. Leaving aside that, the person who has issued the certificate did not deduce any evidence. Now, there is another exhibit, certificate by the village headman, Gaambura, relating to the other village,
Yes.
right? That person has also not been exhibited, but that is
Exactly.
subsequent to that, right? It has been adduced as an evidence, but not been proved. Now, which is the way how you have proved before the tribunal?
No, well, I have some,
Is that the NRC document which you have submitted later, but those cannot be considered because they are not yet finalized, nothing, no final list has been proved. And it is a draft stage only at this moment.
but kindly see 52 page. 52. This is the evidence of Raheton Nessa.
Hmm.
My father is late Sekandar Ali, mother is late Amina Khatun, grandfather is late Sadar Munshi, and were the resident of number 2 Kasarigao under the Diden Murigao PS. In the Diden Nagang district, I have a brother Kashem Ali, sister Asiya Khatun, and were born and brought up in the same village. Later on, we shifted to 5 Boruazar village. I was married to Hassan Ali, son of Kiamat Ali of Hati Lura, Pathar in Morigao, and have a son, Abdul Rahim. After 4 years of our marriage, my husband expired, and thereafter I returned to my parents' house, and I have not casted a vote. My parents have casted vote in 1966, 70. My father's name is recorded in the NRC 1966, 1970, exhibit so. My brother Kashem Ali have casted vote in 1997 and have voter ID card. My brother's name is recorded in the cell deed on dated 10/9/99, exhibit 7. The GB of Gasarigao and Boruazar have issued the certificate, said that I am the daughter of Sekandar Ali, wife of late Hassan Ali, exhibit 8/9. And my brother have used same LDC of my father of 1966, exhibit 10 and 11. I have filed an affidavit, corrected name discrepancies. Then kindly see cross. I don't know what is written in the WS. I have not submitted any land documents to show that my father registered in Kasarigao, in Morigao district. Land document is not in her name, so it is unwarranted cross. The GB of Kasarigao is not present today. I have not submitted the GB certificate of my brother's place. I have not casted vote. In 1966, my father's age is 67 years. In 1970, also my father's age is 67 years. My grandfather is shown as Madari Munshi. So, Lordship would see here, there is no cross regarding the veracity of 66 and 70 voter list. And it is not cross that secondarily is not your father. That is very important thing. The government, learned government advocate did not say that secondarily is not your father.
Is it required?
Yes, it is required because
First of all, it is your case. You have to show that you are the daughter of Secondary Ali.
I
Where
have,
is that? Mere making a statement will not do.
no, I have,
That is why we are asking you. what
I
you
have
again-
said, my lord,
How you have proved? What is your link document to show that you are the daughter of Secondary Ali? There is no demand
I understand that. Link document is that, my lord. Link document, I understand, that is not directly, though Gaura certificate was there.
Let us read the.
Kindly see for a moment again, page 58,
No,
the
we'll come
Kasem
back
Ali's
to that.
witness.
We'll come back to, let us read the evidence of Kasem Ali.
Yes, page 58. Copy is by sister, mother is Amina Khatun, grandfather is less Sodar Munshi, and we are resident of number 3 Kasarigao under Murigaon PS. I was born there. My sister who born there and was shifted to 5 Burwazar village. My father have casted vote on 1966 and 1971. My father's name is recorded in the NRC 1966-71. I am still casting vote. I have voter ID card. I have used LDC of my father of 1966. Cross. My father expired some 30 years back. I have not submitted voter list of 71. I have not submitted any document of Kasaripara village. I am not a foreigner. Now, Lordship would see here, Kasem Ali has adduced evidence. His evidence is only linkage. Now, there is no cross. You are not the brother of Rahitun Nasr. So, why my statement shall not be believed? Because law says any objection should be at the first stage. Then he will get a chance to explain the position. Now, it is not said that Kasem Ali is not your brother or Rahitun Nasr not your sister. Neither of anybody's witness that question was raised or objected under objection. So why it should not be believed? Section 50 of the Evidence Act, it will come. And when it is not objected that Kasem Ali is not your brother or Rahitun Nasr not your sister, either of the two questions to the two persons, that was not asked for. So I think the burden is up to the preponderance and probability. It is not like a criminal case. That proof should be beyond reasonable doubt. Now the learned tribunal has mentioned several things. Here, page 66 may be seen. After five lines, page 66. If he was 44 years in 1997, then his year of birth would be around 1953, and his name should have been recorded in the NRC 1966 or 70, and he should have casted his vote by 1975. However, the opposite party failed to submit any voter list of her brother after 77, after 75, and prior to 93. From the voter list of 1997, it is found that he suddenly appeared and entered his name and casted his vote in 1997. So it is only surmise. Suddenly a person cannot get his name recorded in the voter list. So it indicates that the learned tribunal had a perverse mind. Otherwise, suddenly one person cannot come and get his name recorded in the voter list. It is not so easy. And if it is so easy, then they are to be blamed. The government should be blamed. Then Lordship would say from the statement made by opposite party in her evidence and WS which by any account was wholly inadequate to establish her identity as the citizen of India having regard to the mandate of section 9. So it is wrongly quoted because that is not applicable here because I have produced documents. Then Lordship, the exhibit is also no use of opposite party because this is a computer generated statement. Computer generated statement without any certification. So this is totally wrong conception of the landed code. Computer generated voter lists are acceptable. Lordship, I am showing the citation of various courts, my lord. That is 2018. SCC Online, Bombay 206. Here, downloaded copy of order obtained from the internet is acceptable without any signature.
No,
2018 SCC Online, BOM, BOM, BOM 206. Downloaded copy of order obtained from the internet is acceptable. Same thing has been expressed in order of High Court of Himachal Pradesh, number so-and-so, order dated 3rd June 2022 in HSC VIG with instruction /93 Roman 5-15133 order dated 3rd June. So that view has been also accepted by our High Court in WBC number 4830/2018 order dated 22/2019 para 5, 6 and 7. So the
Mr. Mahmood, just tell us one thing. Just now you have seen that voter list of downloaded voter list, right?
Yes.
This is 1997 voter list. Now just tell us whether this is the downloaded voter list from the internet.
it is taken like that by the tribunal.
Please tell us one thing. Whether it is page 27 is the downloaded voter list?
I think
Or
it is. I
page
think it is not.
26?
I think it is not, because it is not downloaded, but Learned Tribunal has said. That's why I am telling. Tribunal is telling that it is without having any certification or signature, and it is downloaded, not acceptable. But law says it is acceptable. In bank statement, Lordship, also if we go, what amount of money I do have, then they will give a statement that is without any signature, but that is acceptable. And so far regarding, no, that Kashem Ali is not your brother. Kashem Ali is not your brother. Then that is not put. And Rahatun Nisa is not your sister. That was also not put in question. So law says that any objection to any document should be at the first stage. I have given the judgment in many cases. I have said here. Here, my lord, in 2006, 5 SCC, 558, para 14, 16, 18, 19, it is said that any document is placed to be asked to produce the same, and question should be asked at the first stage regarding any veracity, if there is any veracity. And when the document has been produced or evidence has been given, but it remained unchallenged, then that is the case of Abdul Khalek Lordship. That is 2013, 1 GLT 941, para 9 and 10. That is division bench judgment of our High Court.
2013 9 GLT.
2013 1 GLT 941, para 9 and 10. Here it is said,
This has
That-
been clarified later on. I think this is Madam Justice Anima Hazarika's judgment.
no, that is a judgment of my Lord Justice BP Kotak.
2013. Oh, along with Justice Goswami. Yes.
Sorry.
So, in that view, my Lord, that is acceptable because they, at that time, they did not raise any objection after that, my Lord. So, our case is that when they have not raised any question regarding the truthfulness, or trustworthiness of the evidence of Qasim Ali and Haidan Nasa, all in a sudden, they cannot say that they are the, of course, your Lordship is correct. There is no legal document. No document is there that is not certified. Your Lordship is correct that their names are not there together. Though it is together, but that is not certified copy. In certified copy, only two persons' name is there. But here, section 50 will come. That they adduced evidence, that was not denied by them. So it should be treated as accepted. And here, most important citation I am giving, 2004, 12 SCC 360. Here, my Lord, any objection regarding a document must be at trial stage, nor thereafter. So, this judgment is enough to establish linkage between Qasim Ali and Haidan Nasa. And in many cases, I have found that shifting of their places have not been said by the proceeding. But here in this case, I see in WS, as well as evidence, she has said that due to erosion, my father shifted to Borwazar in the district of Dorong. And thereafter, I got married with so-and-so person, that is another place. But after 4 years, my husband died, so I came back to my parents' house. In the meantime, parents was nowhere there. I stayed with my brother Qasim Ali. And Qasim Ali is the witness. That is not denied. Haidan Nasa is witness. Says Qasim Ali is brother. That is not objected. So I think I could become able to discharge burden as enunciated under section 9. Because burden is not beyond reasonable doubt. It is preponderance and probability. So for discrepancies in names, my Lord, that is common. Lordship is aware about that. And there is no also cross on that aspect also. So this may have also sufficient. My last judgment, I think that will cover very well about my cases veracity.
Yes, Mr. Bhuilapia Sharma or Mr. Kalita.
Lordship, I am appearing in this. Lordship, the contention raised by the counsel for the proceeding is that the proceedee is the sister of one Qasim. His name is Qasim Ali, and both of them are the son and daughter of Sikandar Ali, whose name appeared in the voter list of 1966 and 70 voter lists. The only thing he has to do is that he has to prove and link Qasim Ali with the proceedee, and then link either the proceedee or Qasim Ali with Sikandar Ali. That is the only thing he has to do, the petitioner. Now, from the evidence, Lordship, whether she could do it or not, that we'll have to find out. For that, Lordship, first of all, Lordship, I will take your Lordship to the WS file by them. It is at page 40, Lordship. I'll not read out the whole thing. Some important informations were not there, when she was born, when she was married, those informations were not there. Those were lacking. I don't know why those informations were not given, though they have filed a very detailed kind of a WS. There may be some reason, I do not know, but they have not mentioned that when she was born and when she was married. But those are very relevant because they have stated in serial number 3 that after her marriage, she spent only 4 years with her husband, and after her husband death, she returned back to her parental home. So it makes it a little bit relevant that when she was married and when she has again come back to her parental home, because she is trying to show by submitting some voter lists. Of course, those voter lists are not admissible because those voter lists are not certified copies. So at least they are trying to show that when one voter list, she has casted vote along with her brother from one village. So that becomes it becomes important for the proceeding to show that when she was married and when she has come back to her parental home again. That hasn't been mentioned there. So in WS, Lordship, I don't have nothing much more to say. Then, your Lordship, I'll take your Lordship directly to the deposition of Rahatan Nessa, the proceeding. That this nails the whole thing. So page 52, Lordship. My learned senior friend has already read out the whole contents of the examination and cross-examination part. I'll just take your Lordship to the cross-examination part at page 53. So she has stated many things that whatever she has stated in the WS, the same thing she has stated here. So in the cross-examination part, the very first line, Lordship, which negates all her claims, all her contentions in the writ petition. What she says is that I do not know what is written in the WS. It takes away everything here also. It nullifies whatever the claims she has made in the WS, whatever the claims she has made in the evidence part also, because the evidence was made on the basis of the WS. When the WS goes, everything goes. So she states that I do not know what is written in the WS. I have not submitted any land documents to show that my father registered in Kocharigaon in Morigaon. The GB of Kocharigaon is not present today. I have not submitted GB certificate of my brother's place. I have not casted vote. 1960, this is not very relevant, but these 4 lines, Lordship. I have not submitted any land documents to show that my father registered in Kocharigaon in Morigaon. So what she is basically trying to say that whether they were in Kocharigaon or not, she is not sure. The GB of Kocharigaon is not present today. I have not submitted GB certificate of my brother's place. And I have not casted any vote. Then Lordship, I'll take your Lordship to page 58.
No, it is, I have not submitted any land document
Lordship,
to show that my father resided
in Kacharigaon, in
Kocharigaon or Morigaon.
Morigaon. It should have been.
The GB of Kochari
Gaon is not present today.
Gaon or Para is not present today.
Yes, Lordship.
I have not submitted the GB certificate of my
I have not submitted a vote after the. Very difficult to read, Lordship, from here.
some place. Husband's place.
Husband's place. But this is clear, Lordship, but
Or I have all voter. Casted voter. In casted vote in 1966. I have in 1960. I have not casted vote. It did not cast. She said, I have not cast vote.
she hasn't casted vote. That is a very clear and specific statement.
In 1966, my father age is 67 years. In 1970 also, my father's age was 67 years.
That I'll come, because there are certain things to be shown from there also, Lordship. There are certain things to be shown from there
So
also.
according to you, the first sentence of the
That takes away everything, your Lordship.
doesn't know what is stated in the.
Yes. So her claim about citizenship, her claim about somebody secondary Ali is her father, everything goes. It becomes a nullity.
Then
Then Lordship, Kasem Ali's evidence, Lordship. Kasem Ali, the brother, is at page 58, Lordship. From here, Lordship, I just wanted to show one line that is in the cross part. My father expired some 30 years back. So this was recorded on 23rd May 2018. So Lordship, if we calculate it, so this Secondary Ali must have been dead in 1988. So from 70 onwards till 1998, not a single voter list. Can it be believed? Can it be believed that somebody has given two voter lists of 1966 and 70? Then till 1988, there was not a single voter list, and he hasn't submitted a single voter list because he doesn't have it. Because these documents have been created. Now, Lordship, page 18. Page 18, Lordship, that primary document of theirs, that is the voter list of 1966, wherein Muhammad Secondar Ali's name features. Secondar Ali and Amina Khatun. Secondar Ali is 67 years of age in 1966. Amina Khatun 51. Then the village is Kacharigam, of course. Then in page 20 also, 1970 voter list. There also one Secondar Ali is there. Amina Khatun is there. Village same, Kacharigam. But the age remains the same, of course. The 67. Here also 67. There also 67 and 51. Now, Lordship, one thing we'll have to connect with this voter list is that the voter list of 1997, that is at page 25, Your Lordship. This first voter list of 1997, which is there in the voter list, this is not a certified copy. So this is not admissible, Lordship. So I'm not referring to this. This is not admissible as per law. But the other voter list of 1997, that is at page 27, Your Lordship. This is a voter list, computer generated voter list. Is at page 27 and 28. Herein Kasem Ali's name has come. His age is 44 years. So for the first time, his name has come in a voter list when his age is 44 years. So if we take his age as 44 years, then he was born in 1953. If we calculate it, then it becomes 1953. So if he was born in 1953, then he becomes major. I mean, he can franchise. He can make his franchise at the age of in the year of 1974. So from 1974 that he has been residing in India, there is no voter list. Nothing. So that creates, a hell lot of suspicion that how come a person staying in India from 1953, he was born in 1953, he was a major in 1974, he doesn't have a voter list till 2010.
Till 1997.
Till 1997. I'm sorry, Lord. Till 1997. So another voter list he submits, that is of 2010, that is also not admissible. It's not a certified copy, which is there at page 29, 30. So there is no link between Kasem Ali and Rahit Nisa. There is no evidence bringing on record showing that Kasem Ali and Rahit Nisa are sisters. First thing. And secondly, there is no document showing that Secondar Ali is the father of Kasem Ali and Rahit Nisa. Of course, they tried to bring on record through certificates, the Gaunbura certificates. And those Gaunbura certificates, Lordship, cannot be considered as admissible evidence because the Gaunburas were not examined. So that can be negated as per law. So other than Gaunbura certificate, in my humble submission, there is no document. There is no document to show in evidence that Rahit Nisa is the daughter of one Secondar Ali. And also that Kasem Ali is the son of Secondar Ali. There is no evidence, Lordship. There is no document. And whatever the oral evidence they have brought in, that I have Lordship, I have already pointed out that the first statement of, in the cross-examination part of the proceedings, the whole thing has been negated. So Lordship, one voter list is only there on record. There is 1997 voter list, which is Kasem Ali's voter list, which is at page 27. There only the mention of one secondary rally is there, but like they could not link this secondary rally with the voter list of 1966 and 77 secondary rally. There is, they could not bring in any evidence in that regard, you know.
Anything else?
One thing, Lordship, just one second. Lordship, as far the case laws are concerned, case laws that have been cited, the one Lordship, as far as that rebuttal of evidence, my one senior has pointed out that
What Mr. Mahmood has said regarding the document, it should have been raised at
at the very beginning,
and it has not been objected by the court,
correct, Lordship,
or no question as such has been asked
correct,
by the court.
absolutely. Lordship.
By
So
the
in that
state.
regard, Lordship, there is a settled law, Lordship, it's a settled law. There is a case law, Lordship, I'll just refer to WPC 2641 of 2017. It's the state of Assam and another versus Ohavali. This is a case of 2017.
2641.
Yes, Lord. So much later than the case cited by my learned senior, Khalik, Abdul Khalik. So in para 16, your Lordship will find. May I just read out para 16? On the other hand, from the impugn order, we find that after narrating the case as projected by the respondent, the tribunal observed that state did not examine any witness and failed to adduce any rebuttal evidence. Therefore, the tribunal answered the reference against the state. We are afraid the approach taken by the tribunal is contrary to the law laid down in the full bench of this court in State of Assam versus Muslim Mandal reported in 2013 1 GLT 809. Under Section 9 of Foreigners Act 1946, the burden is on the proceedee to prove that she is not a foreigner but a citizen of India, and this burden never shifts. This is very important. This burden never shifts. This burden has not been discharged by the producer by adducing evidence which are admissible, which must be proved, and which must have relevance to the facts in issue. By mere filing of documents without examining its admissibility and without the documents being proved or without examining its relevance, it cannot be said that the proceedee had discharged his burden. Question of rebuttal of evidence by state will arise only if the proceedee adduces evidence which are admissible, proved, and which have relevance. This is the first principle, Lordship. The second principle, Lordship, as far as voter list is concerned, my learned friend, senior friend has relied on the voter list. So as far as voter list, Lordship, this case law, WPC C2370 of 2023.
3270.
Yes, of 2023. 2370 of 2023. Aziz Mia versus Union of India and others. The paragraph 41, which is relevant here also.
Kindly read.
I'll read it. Para 14 here, Lordship. We are constrained to observe that
Para
mere
14 or 41.
14 Lordship, 1/4. So here, Lordship, they have claimed that secondarily is the by by submitting the voter list of 1997, showing the name of secondary Ali in the voter list. They are trying to show that this secondary Ali is the same secondary Ali of 1966 and 70. So he is my grandfather, he is my father. So he was staying prior to 1971. So yeah, we are also citizens of India. That is his claim. So in this case, Lordship, what the Honorable Division Bench of this Honorable High Court has said, that we are constrained to observe that mere claim by a suspected person by referring to a voter list, claiming a person therein to be his father, is not a conclusive proof. And that by doing so, the person has discharged the burden that he is not a foreigner. This is because there is also further requirement to prove that person who is reflected in the voter list relied upon is actually the father of the person who makes the claim. The claim will have to be substantiated with further materials accepted in law. So this nails it, Lordship. This says that only by referring a person's name in the voter list, it cannot be accepted. That is not enough. That is not sufficient. You'll have to substantiate it with some other evidence which is admissible under law. So that hasn't been done here. They tried to do it by the GP certificate, but the Gambura was not examined. So in my humble submission, Lordship, this case doesn't warrant the interference of this Honorable Court, because they miserably failed to link the proceeding with the person secondarily in the voter list of 1966 and 70. And if they have failed to do so, then they have failed to make any case out of the case. That's my humble submission. Obliged.
A very short reply, my lord. First thing, WS ki likha hai wo another note. That should not be taken so much seriously because she has also adduced evidence. She has also adduced evidence. But in evidence, she has clearly stated everything. So one sentence, if taken so much seriously, then her so many statements are also there which says that I am the daughter of secondarily. That should be also believed. You are believing one sentence and by that sentence you want to take my case away. But she has said many things, you do not believe this. So that is my humble reply. Secondly, land document, she has said that I have not produced any land document of my brother. She has adduced the land document of her brother with father. She has not said that land document is there, but land document is in the name of her brother Kasim Ali with father secondarily. So that is not a contradiction. And there are no any land document in her name. In the name of her brother and father, that she has said. Now, my lord, GB certificate, what my learned friend has said, GB certificate, I do not, because she has not come. So that is should be GB Gambura has not come. So it is not a matter. Gambura has not deduced evidence. And now documents, my learned friend has said documents has been created. How? Then why you have not filed any criminal case against me? Documents have been created. How? This rightly or wrongly, these are exhibited, these were before the learned tribunal. If I have created documents, why you did not file any criminal case against me? Next thing, my lord, question is this: the Kashima list, voter list, 45 years as is written there. My lord, Kashim Ali case is against Rahatan Nation, not against Kashim Ali. That voter list has been brought only to establish linkage. So, a man becomes voter at the age of 18 or 21. It is not, he only wants to show that my father is Secondar Ali and Rahatan's father is also Secondar. So, voter list of 50 years or 60 years doesn't matter. Because case is of Rahatan Nation, not Kashim Ali. So, Kashim Ali is not required to discharge his burden. Kashim Ali has brought the voter list, certified copy, when he was age of 45 years, at that time it was available to prove the thing that Secondar Ali is our common father. The substantial evidence that documents have to be substantiated, yes. Through Kashim Ali, I have substantiated. I have substantiated my documents contents through Kashim Ali. Of course, if the government would have come, it was better, but it is not bad because of Kashim Ali. That is my reply.
Mr. M.U. Mahmood. Okay. And Mr. A. Kolita, London Standing Council, Home Department, Assam, for the respondent numbers. Two, 6, and 7. Also heard. Ms. London CGC, for the respondent number 1. Mr. H. Puli, Standing Council Election Commission of India, for the respondent number 3. Mr. H. Hazarika, H.K. Hazarika, London Government Advocate, Assam, for the respondent number 5. Peruse the records of FT case number FT put in capital Roman 5 1772 of 2016. Decided on 08/06/2018. That was called for from the Foreigners Tribunal 5th Lorong, Mongol. Involved in this activity. Arguments are heard at night. Order. What's the